Hi, and welcome back. Now that we've discussed litigation, what it is and its benefits and its drawbacks, let's turn to the issue of ethical consideration in litigation. Now, there are numerous areas of possible ethical dilemmas, and I thought I would illustrate just a few of them here, starting with the duty of candor to the tribunal. Now, in this case, we're talking about candor. Candor means truthfulness and honesty, and it can raise a conflict when an attorney who owes a duty of loyalty to their client also owes a duty of loyalty to the court. And so an attorney can never lie to the court. The attorney can never put a witness on the stand that the attorney knows is going to lie to the court. So in litigation, you as a client must understand that your attorney will have differing interest in terms of their honesty and truthfulness. Furthermore, disclosure of relevant information. What should an attorney disclose to the court about a situation? What sort of information is an attorney obligated to report to the court and what is not? Frivolous lawsuits, this is an area that we've heard a lot about in recent years. And frivolous lawsuits, which is to say using litigation as a means of obtaining gain, of creating value, it has numerous consequences. First of all, starting with the idea of the abuse of process. Frivolous lawsuits waste valuable court resources and time, and they divert attention from legitimate cases. Frivolous lawsuits can undermine public trust. If you are hearing in the news about frequent frivolous lawsuits, that can erode your trust in the legal system. And of course, there are economic consequences as well. Frivolous lawsuits increase insurance premiums. They create higher costs for business and have a chilling effect on innovation. For instance, there has been in the last few years an explosion of litigation regarding claims for hail damage to a roof. People have been claiming hail damage to their businesses as a result of, and oftentimes this is a result of not actual hail, but of simply weathering over time. Well, what has happened as a result of that? Hail damage insurance has become much more expensive, and in some areas of the country is no longer even available. Another possible ethical dilemma has to do with the conflict between zealous advocacy and professionalism. Now, an attorney is charged with the obligation of being a zealous advocate for their client. Zealous advocacy is the ethical responsibility of a lawyer to represent a client's interest within the law while also doing everything reasonable to help them achieve their goal. Nevertheless, we have to balance aggressive representation with ethical conduct. This was a problem faced in the state of Texas back in the 1980s. In Dallas, for instance, Dallas was ground zero for a phenomenon known as Rambo litigation. And what Rambo litigation included was the idea that an attorney should always have the client's interest foremost, that the attorney should always operate within the legal confines of the law, but need not go beyond that legal compliance. And what this led to was really an abuse of the process. For instance, in terms of discovery, depositions, which is to say recording oral testimony, which should have taken a matter of few hours, were stretched to last for days simply because there was no rule forbidding depositions for lasting that long. So what the Texas Supreme Court did was they produced what was called the Texas Lawyers' Creed. And the Texas Lawyers' Creed was aimed at creating a set of aspirational principles for attorneys in the state to follow. And so the Texas Lawyers Creed outlines the duties that lawyers owe to the legal system, as well as to their clients, to other lawyers, and to the judiciary, judges. So I have a copy of the Texas Lawyers Creed posted online, and I've also got a memo explaining essentially what it is. But the creed addresses ethical considerations in litigation in several ways. Has it been successful? In a way, yes. Back in the days of Rambo litigation, if you needed a continuance on a hearing, even a minor hearing, because your mother had passed away and you need to go to the funeral, the other side would not grant an agreement to that. Why? Because it might hurt their client. They are better off holding that hearing today rather than waiting till next week after the funeral is concluded. And so in today's system, the Texas Lawyers Creed kind of suppresses that sort of behavior. Confidentiality, obviously another area ripe for ethical dilemmas, because there's a conflict between protecting your client information and your duty to society as a whole. And so there is a balancing act of sorts between these two ideas. We see it all the times in questions of attorney-client privilege. I used to do a bit of criminal defense work back in the day, and I would often work on cases that were assigned to me by a court. This is how public representation is done in the state of Texas. You are assigned defense of a defendant. And in this particular case, the defendant had been arrested for possession of a small amount of cocaine. Well, when I went to interview him in prison, or in jail at that time, he started laughing that although they had charged him with possession of a small amount of powder cocaine, the police had completely missed a bag of crack cocaine that was in his nightstand. When the police left, having arrested him, the first phone call that my client made was to his girlfriend, telling her to go retrieve the bag of crack cocaine. This was obviously a very different situation. This was not a misdemeanor possession of a small amount of cocaine. It was now actually a felony. It would have been a felony for dealing in drugs. Nevertheless, because of attorney-client privilege, I could not reveal that information to the court. Remember, the privilege in the attorney-client privilege belongs to the client, and it can only be violated if the client allows it to be violated. So in my case, we were able to reach a settlement that resulted in a short term of incarceration for my client, and he went back out on the streets and probably started dealing drugs again. Well, who knows? Conflicts of interest arise all the time. Oftentimes there are conflicts between clients, attorneys, or third parties. I'd mentioned contingency fees in the last lecture. Contingency fees can create ethical dilemmas because it may be to a lawyer's benefit to settle early for a smaller amount and bring that money into his account rather than to continue working the file until trial, at which point there may be a greater judgment for the client. In terms of litigation, if you are working on a contingency fee basis, you want to do the least amount of work possible for the greatest return possible. And so sometimes the interest of the client may actually be opposed to the interest of the attorney. Settlement considerations in litigation, there's constant pressure to settle cases, to resolve cases without going forward. And there is an ethical duty to explore reasonable settlement options. Things like fairness and good faith and disclosure are often not present in settlement considerations. We'll talk about that a bit more when we get to ADR and the ethical considerations present there. So how do we resolve these? Well, we focus on developing a legal strategy to focus on how are we going to make legal decisions. And we start with client counseling. Attorneys should always assess what are the client's goals. Is it primarily financial? Are they concerned about future lawsuits? One should create some sort of strategy. And you should also discuss things like risk tolerance. Make sure the client understands that the outcome may not be what the client wants. And so how much of a risk is the client willing to take? And then, of course, we need to fully explain the financial constraints that are going to be involved with litigation. That if you are in a complex piece of commercial litigation, the parties may work for years, incurring millions of dollars in attorney's fees, and then many companies would not be able to pay that. Attorneys should also focus on case evaluation. They should analyze the strengths and weaknesses of each case, and again, discuss the potential outcomes with the client. Litigation budgeting is also an important way of managing ethical dilemmas. Estimate the cost, be realistic in what the costs are going to be, and also set realistic expectations. The last thing I want to talk about is current trends and issues in business litigation, and probably the most prevalent trend that I've seen within the last just few years has been the growth of what are called nuclear verdicts. And a nuclear verdict is a large financial award given by a jury in a civil lawsuit, and it is usually for a verdict that is much larger than anyone expected, much larger than in most other types of cases. Now again, Texas has sort of been ground zero for nuclear verdicts, and so that's why I pick on them here. But between 2009 and 2023, Texas led the country in nuclear verdicts with 200 verdicts totaling over $45 billion. And I'll talk about just a few examples from just the last 2 or 3 years, starting with a case called Werner Enterprises. Now, in this case, the facts of it are tragedy. They're tragic. A family was driving on the highway in the panhandle of Texas during snowy conditions. And what happened was the driver of the vehicle lost control of the vehicle on the slippery highway. He then crossed a median 30 feet wide, a grassy median. He drove up on the opposite side of the highway, going in the wrong direction. At the same time, a 18-wheeler owned by Werner Enterprises was driving down in its appropriate direction, and they were averaging about 50 miles per hour, which is to say 20 miles per hour less than the posted speed limit. And there was a crash, and there was some injuries and a death. And so the passenger in the vehicle sued not the driver of the vehicle, but they sued the truck which the vehicle had run into. The truck which was doing exactly what it was supposed to do in those situations. And so they sued Werner Enterprises, arguing essentially that the company had a responsibility to reroute their driver to somewhere with better conditions. So essentially making the argument that if the truck had not been there, the accident never would have happened. Well, this resulted in almost a $100 million verdict, which has been upheld by the Court of Appeals, is presently on appeal to the Texas Supreme Court. We don't know if there will be settled before then, but we're talking about a $100 million verdict in favor of a party who ran into the defendant's vehicle. From 2024, ExxonMobil was hit with a verdict for $725 million This was brought by a former auto mechanic who, when he was an auto mechanic, would routinely wash his tools, his greasy tools, in gasoline. Gasoline often used to clean items. It is a solvent and does a very good job of removing grease. However, it was never recommended for that purpose, and ExxonMobil never tried to pressure anyone or advertise gasoline to be used to clean tools. Nevertheless, this person, this auto mechanic, later developed cancer, and he blamed it on his exposure to gasoline, washing his hands in gasoline, and that resulted in a $725 million verdict for causing cancer. Finally, this is again from 2 years ago, I think, Charter Spectrum, a cable company, a $7.37 billion verdict. This case was, again, terrible facts. A cable installer who had repairman who had a history of depression, who worked for Charter Spectrum, had gone to a company, gone to a cable owner's house to fix the cable. It was owned by an older woman, a 73-year-old woman, and he fixed her cable and he left. Now, the next day, the driver, who was not working, he snuck into the yard where the trucks were kept, the cable company trucks were kept. He stole a truck, he went out, and he returned to the house that he had been at the previous day, the woman's house. Knocked on the door, and she, seeing the cable guy who was just there yesterday, let him in, and then he proceeded to kill her and take her credit cards. So, terrible facts, no doubt. The defense of the cable company is like, this really has nothing to do with us, that there was no criminal history of this man that would indicate that he would do something like this. And in fact, he wasn't working when the crime was committed. He had stolen a truck from the cable company. Nevertheless, the jury comes back with a verdict for $7.37 billion. And you just have to wonder, do people really understand money and how money works? And how much is $7 billion? So that's nuclear verdicts. And again, there have been much discussion of these in the news, and I expect we will continue to see those. The other area that we've seen a lot, really in the last 2 decades, has to do with class action lawsuits. These have become really common in recent years. We've all been a member of a class action. You get a little card in the mail, or you get an email telling you that you are a member of the class, and to give your address, and you'll receive some sort of settlement out of the deal. Well, there's multiple ethical considerations here, because ultimately the members of the class receive very little. I have been a part of multiple class actions, and I don't think I ever got anything more than $24. Meanwhile, attorneys are making millions and millions of dollars on these cases. So once again, we have to balance competing interests. We have to focus on balancing what's good for society, but what is ultimately harmful to society as well. So in conclusion, what did we learn today? There are numerous areas of possible ethical dilemmas arising out of litigation. Companies should develop a litigation strategy, and nuclear verdicts threaten the stability of the system. That's all for this one. Thanks for listening, and I will see you in the next lecture. Thanks. Bye.